Hello, good morning or good afternoon. Welcome to this Spider webinar titled Artificial Intelligence and Intellectual Property in International Cooperation. This event is being recorded and will be available after the event. My name is Krista and I am moderating the session. To start, I want to give a brief explanation about our project. I want to share a quick presentation. I don't know if now you can see my screen.
We can see, we saw it, but not in the presentation mode.
Okay.
I'll let you know when we see it fully.
Okay. Now you can see it.
Yes, perfect now.
Perfect. To start, I will start with the presentation about our project. So what is the Spider project? Spider is the strategic partnership of the implementation of digital dialogues in research and innovation in cooperation. Now we are building our community of practice, and the main objective of our community is to forging strategic partnerships and championing an inclusive and human-centered digital transformation through Europe and Latin American and the Caribbean. So here is a QR where you can find a link to join to our community. And later we also can share the direct link to our community. So why join to our COP? Here you can have strategic partnerships, priority knowledge access to some research that the project have also in this moment. So also you can have a space to peer-to-peer collaboration, a space also to learning and have updates, and to have a space to visibility and recognition. So here is a screenshot from our space, our digital space. Here you can have in home all about what is Spider and some documents that are available. Also, you can have a space to have a list of members, the people who is now in the community. Also have a space to share your ideas in a forum. Also have a direct chat to have a communication with the other members. A list of our events, our common events, and also finally we have a repository where you can find, as I mentioned, the last research documents that have about our project and um, other digital dialogues that are now developing in Europe and Latin America. Sorry. So today, now I am very glad to introduce Giovanna Girardi. Giovanna is a lawyer and intellectual property expert of the Latin America IP SMA Helpdesk. Joanna is clients hire her to build strategies to project their designs, patents, and trademarks, and also profit from them. Giovanna also lectures at various business schools, Geneva Business School, AIA, Garrides, and collaborates in global and European to raise awareness of intellectual property rights as a competitive tool of ESMAs. She also participated in an ambitious project for the European Union Intellectual Property Office to help harmonize practices within the network of European Union intellectual property offices. And Joanna was born and raised in Brazil and holds a master's degree from Pontificia Comillas University. And you can also follow her insights in intellectual property in LinkedIn and Instagram. So thank you so much, Joanna, for being here today. And the floor is yours.
Thank you, Krista. Thank you, the Spider Project, for asking me to do this presentation, and everyone that joined us to listen to what I have to say. Before I deep dive into what we're going to talk about, I just need to introduce who is the Latin American Help Desk and what do we do in the Latin American Help Desk.
Sorry.
Yes.
I think that your screen is it's not presenting all the document.
Okay.
Not the entire screen.
Let's try.
Not yet.
Now you are perfect.
Cool. Okay, so I'm just gonna introduce a little bit of what the Latin American IP Help Desk is and what we do. The Latin American IP SME Help Desk is part of six funded help desks that offer resources, informational resources to small and medium-sized businesses based on the European Single Market Program, which includes all the member states plus Turkey plus Ukraine plus the Balkan countries. So all small and medium-sized companies based in any of these territories can be beneficiary of our informational services that include first line of assistance, the trainings, and the material we have online. These six help desks have different geographical scope, precisely because intellectual property are territorial rights, and it's important that we understand what locally where we are going in our destination, what is required there, because IP is so territory focused. We have six different help desks with different geographical scope. We have Africa, the European one, India, China, Southeast Asia, and of course the Latin American one. The services we provide are all the same. They are all free of charge, being the most relevant to you, the users, the first line of assistance, in which we are committed to delivering an answer to your query, to your issue, in which intellectual property rights play a relevant role in 3 working days, with the utmost confidentiality, personalized, clear, concise, to the point for the business running. We also, as I said, have lots of online resources on country and sector fact sheets, guides, case studies, and training model. I believe case studies for me is the best piece of material we have online because it brings quite a learning curve in what not to do. We also are online and offline with the trainings. We are in fairs and events. We have local experience both within the EU and within the region. We have focused particular the Latin America Helpdesk. We have experts throughout the Latin American territory that are there to help the European single market program companies, small and medium-sized. You can find us on the European Commission website, ec.europa.eu/IP helpdesk. You can also find us on LinkedIn and Twitter or X. This is our contact details. And before I deep dive really in the content for today, I need to ask a question, and I ask you to take a minute to answer this question in the chat box. Okay, the question is simple. It's just to measure the impact we're having with the training. What is a patent? Is an exclusive right to a logo? Is an exclusive right to an innovation? Is an exclusive right to a novel technical solution? Please give me your answer in the chat.
Do we have a chat? I don't see it.
Yes, you can see it.
Okay, I found it.
I'll give you a few seconds more for you to answer the question, which I will repeat at the end of the training. Exactly the same question, and let's see if we can find the right answer for that. Okay, so the topic here I was asked to talk about is AI and IP in the era of AI, and what is the opportunity? What is the opportunity there? And a few questions that put the two together. So the first thing we need to understand, intellectual property rights, these intangible assets, patents, trademarks, copyright, designs, all intangible assets, all intellectual property rights governs who owns the value in ideas. It's about ownership. Intellectual property rights, intangible asset, is about ownership. And AI governs how the value is produced. So it's a tool to produce value. What is ownership about then? Is about exclusive use, is about competitive advantage, is about income generation, is about defense of commercial interest against non-authorized use. So to me, is a triad. Exclusive use, income generation, and commercial defense of your business interests. Value in ideas is the business itself, is the consumption, is the money coming in. The value is the money coming in for the business. So here, when I think of value, I think we need to look into three perspectives. The perspective of what are the rights, what are the assets that within the idea I have will enable consumption. What are the rights that will enable consumption? What are the rights that will enable commercial relationships? What are the rights that will enable defense of my exclusivity, my competitive advantage? This three it needs to be looking at in the life cycle of the idea, starting for idea generation there, where we're in research and development, where we have partnership. I understand where most of you are today, the cooperation we are talking about between universities and a private sector, the cooperation between universities from EU and Latin America. That's probably or potentially where most of you are today. And there as well is not only a matter of understanding the ownership, what is being generated, and then what is going to create value, or in simple terms, what was going to create income, but also understand how these relationships need to be established and evolve. And this is not only you see throughout the life cycle of the idea, or what you put in the market, you're offering, try the life cycle of that product or that service that you're creating. There's always a play between owning the asset and structuring the relationships that will enable the asset to bring income. Yeah. So it's important to identify which assets will play a role in each of the phases of the life cycle of this idea: the research and development, the launch of the offering, the growth phase of this offering, the maturity, and then eventually the exit. I don't want to be part, I don't want to manage this asset anymore. Like, what do I need to put in place here now to make a little bit of money, and also to discontinue my responsibilities as the manager of this asset, So important to understand the trademarks designs, what are they operating there for, and again, to bring consumption, creating the need for commercial partnerships, and defending the interests of the business. We have a trademark. This is what consumer will see immediately. Consumer will look for the symbol you use in commerce to gain recognition in the market, your trademark. In legal terms, is the exclusive right to that brand identity element you need. The design, which is the exclusive right to the external aspect, features of the product or its packaging. The patent, with is the exclusive right to the novel technical solution to a problem with industry applicability. And copyright, which will be the exclusive right to the creative works, including codes, computer programs, database, technical drawings, the website, images, so on and so forth. Now, the relevant assets, seen in simple terms just for our clear understanding, the name and the logo as a trademark, the exclusive right to the symbol you use in commerce to create consumption. There we see Solán de Cabras and Evian, two water providers. We have also the appearance of the product or the packaging, as the design. You can see there the bottle there is fairly different and does catch the eye of the consumer in the shelf, thus enable the consumption in a busy shelf. And the technical inventions, process of function, innovation. In the terms of a patent, you see there the cap, the cap of the water bottle. I bought two examples there. You can see the technical invention, the technical solution is fairly different. It's the same purpose, but it's fairly different. So we have many possibilities there. But the idea here is that the examples are fairly simple, so where we can clearly understand what each of these rights actually represents and it can be used for. And then we have the software, the training materials, the website, the marketing materials as a copyright. Now, owning the value of this idea, because I started saying that intellectual property rights, intangible assets is all about ownership. And ownership is gained through registration of these assets in or within the local relevant authority where you have commercial interest. So to own one of these rights, to own a trademark, to own a patent, to own a design, to own a copyright, we need to submit a formal application to the relevant authority in the territory you have commercial interest. And here it's important to have in mind that we need to fulfill local legal requirements. Though in some territories you will be able to use the advent of some international treaties that enable the registration from the comfort of our homes in our home country. We still need, for them to be registered, for them to be granted, we still need to meet the local legal requirements. Now, then the other very important thing we need to know about owning the value of our intangible assets is that they are sensitive to time, either because we have a principle in that particular territory, we have commercial interests, that is called the first to file principle, which means the first person, the first company that file for the registration of that right will become the owner, or because we have novelty requirements, and novelty means that whatever we're trying to register needs to be new, and novelty is not a local requirement, it's a global requirement. Novelty, the technical solution or the design needs to be novel everywhere in the world to be registered locally there, whatever we want to have the right. So in Latin America, we can use international systems managed by the World Intellectual Property Organization to register patents, trademarks, and designs. However, not in all countries. For patents, you have the list there: Brazil, Chile, Cuba, Colombia, Costa Rica, Dominican Republic, Guatemala, Ecuador, Nicaragua, Peru. For trademarks, you can only use the system, this international system, Brazil, Chile, Colombia, Cuba, and Mexico. And for designs, unfortunately, only 2 Latin American countries are members of the treaties that enable the World Intellectual Property Organization manage the registration of these rights. So in the case of the other countries, for the registration, the countries that are not member to the treaties that enable OMPI, you would have to file this formal request for the relevant right in the relevant country with the national authority, with the National Intellectual Property Office. Following the existence of the right, follow giving birth of the right, or declaring the ownership of the right, we have the management of the right, the management of the assets. And in practice, we have there five mementos, five steps, mementos, I would say, in which it's clear that something needs to be done. One is registration. To acquire the right, to be the owner of the right, we need to register it. The second moment where it's relevant is the maintenance of the right. For me to be able to defend the business interests, the right not only needs to be registered, but needs to be maintained. And maintain, maybe you need to pay renewals, annuities. Maybe you need to file declarations of use, or you have certain obligations of use in certain territories, or also your contracts, the contracts where that asset, that intangible asset plays a relevant role, you also need to do something with those contracts. So registration, maintenance, monitoring, you need to keep an eye to what's happening in the market, so you know when to take action when there is an unauthorized use, because the relevance of the right is precisely that, being able to have the exclusive use and decide when and who is allowed that use, the use in itself, and the defense in case of an unauthorized use. Now, IP in the AI era. There's a drama here. There's a drama that it doesn't have an easy answer. Okay. And the drama starts with input, output. With input, what is feeding my AI system? Do I have the rights for what is feeding my AI system? And the output, what my AI system is creating, who owns that? Okay, so that drama is not what we're going to solve today, but to consider who owns what at each moment, the type of use, the risks and liabilities we're facing. And here in risks and liability, is not only thinking of AI only. It's not only about intellectual property. It's about compliance with what is AI playing with, because AI is not playing in a vacuum. AI is playing with, interacting with data protection, is interacting with consumer rights, is interacting with many other areas of law. And to understand precisely what risks and liabilities we have there, we need to understand what specific interactions our AI solution is having. And then knowing all that information, we can have a strategy. So, but here, the solution I hoped to bring you today is not who owned the input and who owned the output, but the solution itself. How is the value, the money being realized or generated? And again, we have to go back to how is consumption being created? How is the end consumer or the partner you need looking at you and coming at you? How is it find you? And here just you see just in the image, these logos and names of many different solutions. And there is solutions for all sorts of fields, from the medical field to the legal field to recently we have worked on market solutions in AI, and also extracting minerals from underwater. The application is really we cannot count all the applications AI will be having in our lives. So here's what is clear to me when we put AI and IP together is how is our consumer, our end consumer, and how our commercial partners or our collaborator, our these technical development partners are finding us. What is their role? What is their role in what we're developing? So it's obvious to me that whatever you're designing, there will be a trademark there will be a code, there will be a software, might be a design, might be a patent, or maybe a trade secret, and a business model in which contracts will be fairly relevant to structurize the relationship you are building. Yeah, so that's how we're generating that value. Again, we go back into all the rights we have, all the trademarks, and they need to comply with local legal requirements: availability, non-descriptiveness, distinctiveness, graphic representation. For patents, we will have novelty as worldwide novelty, inventive step, industry applicability, originality for copyright and authorship. And we cannot forget local legal requirements for contracts. I know so far the presentation may be very dense, but I will bring it down to earth with the case study, okay? So just before entering the case study, we also have to consider the contracts, not only the intangible assets, but the contracts in which these intangible assets play a relevant role. Now, for licenses, for distribution, for cooperation in research and development, the right needs to exist. The object of the contract needs to exist. The existence of intellectual property rights is registration. So if we're still in research and development, we need to establish how is this collaboration, who is putting on what, who is adding, and who is the owner of the final result. Or how is this relationship, this ownership is to be shared, if is to be shared. We also need to take into account territorial specificities regarding the object of the contract, regarding specific, in this case, the patents, the copyright, the designs, the trademark, recordal of these contracts with the relevant authority, the national office, or recordals with other relevant authorities. Now, for a case study, this is a real case study. A Portuguese company that came to the Latin American Helpdesk asking for assistance. They were developing an AI tool to in the area of face recognition. And they partner in the idea creation there with the research and development with a university in Brazil. Obviously, they needed a trademark. They also filed in for a patent, okay, just basic IP rights there. But here, though they have a contract with the university for the research and development, they did it all on their own. They did not have a specialized expert in IP in Brazil that knew the local regulations. Okay, so you can see this is going somewhere. Intangible assets, as I said, is ownership of the R&D results. Ownership is the money you're going to be bringing in then later. And what happened here is that there was a dispute. There was a dispute about though the contract said the results will be owned by the Portuguese company, and there was a contract that said that according to the local legislation in Brazil, once the research and the results were captured, were materialized in Brazil, then it was the university in Brazil the owner of those rights, despite what the contract said. You cannot disrespect the local legislation. And within the local legislation, the owner of those assets, the results of the research and development, was the university. Now, the outcome of the story is there was a possibility to license the result. The university already had someone in the pipeline to license the results of the research. But because there was a contract to explore this technology, the Portuguese company had preference right to acquire the result. So the outcome here was actually fairly positive. The university actually accepted to sell the rights to the Portuguese company for a substantial sum of money, of course, but you know, there was already a contract in place for the license of the result that enable the decision of the Portuguese company of actually buying the result of this R&D. And they bought the rights. They licensed the rights. So you see two agreements there, two different contracts in which intellectual property, intangible assets play an incredible, relevant role. But not only that was needed to kind of close the story of revenue generation in this scenario here. Also, the local legislation in Brazil requires that the license agreement is registered not only with the national relevant authority, it needs to be registered with the national relevant authority, but also with central bank, so that you can then later bring on back to Europe the royalties. And with that, I give the floor. I leave the floor for questions. But I think it's quite clear the lessons in IP strategy, and I dare to say in business strategy, is that the assets need to be registered, they need to be used, they need to be defended, and all the phases need to be in alignment. We need to think of all the rights and the contracts that will enable the business return. Everything needs to be thought out carefully together. And that is my key message for the end of my presentation. I'll leave the floor to all of you in the room to ask your questions. And also, I will repeat the question again, the same question we did at the beginning. The question is, what is a patent? Is a patent an exclusive right to a logo, an exclusive right to an innovation, or an exclusive right to a novel technical solution? I'll leave it in the chat so you can give me your answers again. And any questions you may have, please, I'm here for you. And if you don't have any questions here.
I do, actually. First, Giovanna, thank you so much for your information. And obviously, this is quite interesting, especially as you mentioned in the closing. Well, having this alignment with the business and all in terms of strategy, I think it's an interesting perspective, especially for those that are not necessarily familiar with it. I have a question, and I know this is a really novel, interesting, new developing topic, and it's the issue with IA and all the rights of the content creators, artists, examples. Like, do you think how do you think this is being managed at the moment? Like this tension of who has the ownership of the content that it's elaborated and later it's used by developers to train the AI, and like how can this companies or creators, artists protect themselves and their creations at this moment where obviously the information we have is used to train models?
I think if you're an artist, you should not be using an AI.
Okay.
No, sorry. I don't want
Well, that's your personal opinion, which is valid also.
I don't want to create I'm gonna explain myself, okay? Okay, so from the point of view of the developer of the solution, for the point of view of the developer of the solution, I think is important more than the output is the input. Who owns that input? And that is fairly relevant. It's fairly relevant because intellectual property, if we're using intellectual property rights to develop something, the base of intellectual property rights is that use without authorization for commercial purposes. Okay, so I think it's very important to have that. What is the purpose we are using this input for? Is the purpose commercial? And if it's commercial, then of course I need to reward who owns that input.
Okay.
Yeah. Now, the output, how is the output generated and what is the purpose of the output as well? Now, it's complicated because you have to play with different scenarios, many different scenarios. But generally speaking, the output, what is the purpose? What we'll be using it for? Is for the user or is for yourself? The output, honestly speaking, I have my doubts. Who is? I have serious doubts. But then again, you need to understand. You need to understand what is going to be used for. What is the purpose? Is it commercial purposes? For both ways, because if you're an artist and you're using AI to produce an output, can you really claim is yours for commercial purposes? Mm-hmm. Can you really use without giving the solution, the compensation for the help it gave you?
Okay, I get your point, but I was guessing, for example, those artists or people that you upload your content, that it's yours, it's registered online, and then after, since it's online, like it's being used to train the models.
Here again is fairly, and this has been fairly discussed already, I think. If you're using content input in your solution that is an exclusive use of someone, you need authorization, and that is a compliance act you need to perform. Mm-hmm. You cannot use, it's not because it's online on the web you have the right to use. If you want to have the right to use something, especially if it's for commercial purposes, you need the authorization of the owner. Mm-hmm. No matter, it's the same. You cannot look a logo online and say, I'm going to use it because it's so cute. No, it's not yours, is it? So if it's not yours, what do you need to do? Ask permission. You ask permission. And if you don't have that permission, you cannot use it.
Okay, interesting. And just one last question in this perspective, like at the moment, do we have any legal resources, tools, or frameworks that are being developed in this matter that probably like creators could use to protect their creations?
Okay, in the context of the EU, we do have legislation being developed. Okay, in AI and in copyright. Okay, because when you use the word creators, to me, I'm thinking of artistic work, which generally, in the context we are today, which is International Cooperation for Research and Development, is not the context of today. Mm-hmm. But creators, when you use the word creators, I tend to think you're talking about artistic work. Yeah.
Well, yes, yes. Sorry, keep going.
So copyright is fairly important here. We need to understand always where are we sitting? Where's the context where we're sitting? I can tell you legislation is being developed in the European Union, but not everywhere in the world is being developed, and is being developed at the same pace and with the same structure. So you do have material to work with, but it's not all the same. So we need territory is, when we're talking about law, territory is of the essence. We don't talk about the law in the world. We talk about the law in Spain. We talk about the law in Guatemala. We talk about the law in Brazil. We talk about the law in Argentina, local. And you see from like the case study I brought to you, how the local contract law, not even intangible assets, not AI, the contract law has played a big role in who owned the results of a corporation. Who owned the results of a corporation? That is fairly sensitive for a business. That is fairly sensitive. So territory we cannot discuss anything without actually where is this question you asking me the answer for?
Great. Thank you so much, Giovanna. I think it's a great scope what you told us. Thanks.
You're welcome. I see we have a question in the chat. Can you consider novel technical solution a SW?
Software, sorry.
Okay. Can you consider a novel technical solution as software? A software is a code. Okay? A software is a code. A software can be registered as a patent in certain cases, not all cases, and again, not everywhere. Now, you need to be more specific in your question. Where?
I mean, no. The point is that I'm not sure that your last option, that is innovative technical solution, for me, software can be an innovative technical solution. And
no,
I know.
No.
Okay.
I'm sorry. The understanding is not correct. Okay, a novel technical solution is a solution to a problem. Okay, a new solution to a problem. The software per se is a code, a mathematical formula. Yeah. When you think of a solution, for example, the caps. Yeah. For patent matters, no. In the example I gave there with the water bottle caps, you had to drinking the water without spilling the water. There's two different technical solutions I presented in my slides. Yeah, they have the same purpose, but they are different. I don't know if you remember the image.
No, I couldn't see the image. Sorry, I was driving, so that's why. I mean, I couldn't see the slides. But my point goes that maybe your third point is to ample, to answer. It's a pattern. It's just the understanding of what an innovative technical solution means. That's from my perspective, because an AI algorithm that predicts, for instance, the let's say the progression of a disease at the end is also it's a mathematical formula. I mean, it's a software. It's I don't know how to call it, but and this is an innovative technical solution. So that's why my point was that
a simple mathematical formula is not a technical solution. Okay, yeah, a simple mathematical formula is just a number.
I know, but an algorithm is something bigger, and it's a software. It's okay. I mean, it's not the matter of discussion here. It's just that I didn't understand quite well why you say. I don't know which is the answer to your question in the chat, because it could be all, but I'm not sure that. Is all. That's my point.
It's not all, Maria. Mm-hmm. It's not all.
Okay.
My specific question: what is a patent? Is an exclusive right to a logo. A logo is a symbol you use in commerce. That's a trademark.
It's a trademark. Yes, I'm sure. Yeah.
Is an exclusive right to an innovation? No, because that's too broad. And innovation can be anything. Can be an innovation in a process, an internal process. How I do differently customer relationship. That is innovation. Okay, a patent in legal terms is an exclusive right to a novel technical solution.
That's my point.
to a
That's
novel
my point.
technical solution.
That for me, technical solution can be broader. That's my point. So my point goes to this technical solution, and for me, because I am
It's broad.
a technology,
It is
for
broad.
me it's broad. But I know that in the broad term there are things that cannot be patented. So that's my. It's like a dichotomy. That's the point. Sorry, I didn't want to create any discussion, but from my point of view, a novel technical solution, it's bigger. It's bigger than what can be patented as such. So that's my point.
It's broad because I'm telling you what a patent is. But then to understand what a patent is not, we have to refer back again to the legislation, to the law. And the law says there are matters excluded from being patent. And one of the matters excluded from being patent is a mathematical formula.
That's my point.
Specifically excluded from being a patent.
It's a pity that the term doesn't have the total, that you have to exclude parts in order to have the patent. That's my point. So we used to define a patent, a big term, a global term, an ample term, but then with exclusions. And that's my point, that we cannot find a specific definition for a patent without excluding things from technical innovation. That's my sorry, it's my thought, but anyway, I don't want to continue. I understand what can be patented and what cannot be. My point is more about the term, but anyway, sorry.
I think we need to connect here. When it is a novel technical solution, this technical solution also needs something called the inventive step. Okay, the inventive step is something that is not novel for an expert in the art. For a patent to be granted, not only needs to be novel, but it also needs to have inventive step. And when we talk about a mathematical formula, the reasoning here to exclude mathematical formulas from the object of a patent is because a mathematical formula does not have any inventive step. A mathematical formula is an arrangement of numbers, an arrangement of finding a number. So therefore, there is no inventive step. So the right is, in legal terms, is an exclusive right to a novel technical solution. But the requirements for it to be registered is that it needs to be novel, but also has to have inventive step, and it also needs to have industrial applicability. Because if it's novel, it has inventive step, but you have no application in the industry, then you don't have a patent. Then you have something else. It's not a patent. Like if you have a mathematical formula, you have something else. It's not a patent, but you have something else. Then you need to find out, what do you have? Now, not all softwares are excluded from being a patent. Only the ones that are merely a mathematical formula. Yeah. So we need to, in law, we need to be very specific.
That's the point. That's my point exactly. We are being specific with a very ample term that defines what a patent is, and then you exclude a lot of things. That's my point. Exactly my point. So, but anyway, I understand what a patent is. Definitely, I understand, and I know what a formula is, what an algorithm is, and what. So my point is more about the foundations of the term of patent. But anyway, thank you so much. I'm sorry. Sorry for creating this controversy, but it's just okay. I'm sorry, but anyway, yes, please. I don't know if there are more questions or anyone want to say anything.
I just wanted to say that this discussion helped me understand better what a pattern is, so it was good from my side.
I'm happy about that.
Yes, I think the discussion was very interesting. I don't know if someone else have another question, or we can go to the final. I have a little question. I don't know if those rights when the permission it's granted are retroactive, or it starts when it's granted?
When the permission from the authority, from the relevant authority, I'm not sure if I follow exactly your question.
Yes. From in the specific country.
The rights exist from the moment of application. Okay, but they are pending granting. Okay, so if you have, for example, in a scenario that you have applied for the right is not yet granted, and you have an infringement, a non-authorized use of your right. Obviously, you cannot wait, because sometimes for a patent, for example, depending on the country and the specific subject matter of the patent, because it can be chemistry, it can be mechanical, it can be whatever. The time frame for granting, it can be easily 7 years. So at the moment you apply for, you have certain rights, okay? However, in the scenario where an infringement happens before granting, you have the rights. However, it's still pending granting. Now imagine there is a finding that really there was really an infringement, there is really an unauthorized use, courts grant you compensation, and then later on the patent is not granted. Okay, so you gain here, and later on you're gonna lose it, because they'll come back to you. So like you decided on infringement and unauthorized use of something that was never granted. So you need to put me back in the situation I should have been in that moment. So in certain jurisdiction, although the right is born from the moment you applied for, in certain jurisdictions, you cannot enforce that right until it's granted.
Okay. Yes. Okay.
So there is a gap in the timing there.
Mm-hmm.
But again, territory is fairly relevant for the answer.
Mm-hmm. Yes, of course. Okay, thank you so much, Giovanna. Thank you so much also for accepting our invitation today. You can see the session today later also, and thank you so much for all your information. Was very valuable. So thank you so much, and see you in another time. I hope so.
Thank you.
Always a pleasure. Thank you all for being here today.
Thank
Bye
you. Bye-bye.
bye.
Thank you.